Denzel Spikes. Okay, you're Denzel Spikes.
Yes, ma'am.
Will your client waive the formal reading of the motion and the indictment?
He does, yes.
Judge, we're just proceed on count one. I mean, on allegation number one, we'll abandon the rest. That is the condition.
Mr. Spikes, in cause number 25, DCCR 0921, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from April 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. I'm going to need some explanation.
On
The punishment,
his 3, Judge,
he's on probation for aggravated assault with a deadly weapon, commits another one.
just the newest one was not as egregious as it seems. It was a kind of a mutual combat, but
Okay, let me look at
therefore we're proceeding on that with the lower offer due to the nature of it, but not to continue him on probation.
Okay, give me a second. So give me just a second. I'm going through a couple things. Okay. All right. So I have, again, some paperwork here that has your signature on it. Did you go over that with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Look at one more thing before I do this. Let's see, 24. I'm printing something. Bless you. I'm just looking now at the PC from the original case. I'm looking at the PC from the new case.
Right here, the courtroom atmosphere starts to shift. You can already tell this isn't going to be a routine hearing. Every answer, every pause, and every glance between the attorneys matters. Judges often begin gathering impressions long before a final decision is made. And here's the question for you. Do you think a defendant's attitude inside the courtroom can influence the outcome, even before the evidence is fully discussed?
I'm just not feeling real comfortable with that low. I understand in the new case, potentially some issues if there was some mutual combat, but the underlying offense and the fact that we're resorting to the same thing and grabbing things and beating people with them is concerning. No criminal history. All right, state tenders number 1 in 25 DCCR 0921.
No objection, Judge.
It's admitted. Any evidence Mr. Spikes is not competent?
No, Judge.
All right, sir. In cause number 25 DCCR 0921, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1642. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges in the state's elected to proceed on count 1 only. It alleges that you committed the new offense of aggravated assault that we just with a deadly weapon, the one that we just went through, April 29th of 2025. And is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
I have here on the tablet also some paperwork in that case that has your signature on it. Before you signed it, did you go over it with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, again, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Mr. Spikes, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in each of these cases. I'm handing you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here. Ms. Richmond, in cause number 24, DCCR 2306, you're charged with the state jail felony offense of theft with previous theft convictions from September 9th of 2024. The indictment alleges you were previously convicted of theft June 21st of 2019. And then after that was final, you were convicted of theft in 2 cases on the same date, March 21st of 2024 in Bell County, and then again April 10th of 2024 in McLennan County, Texas, and May 31st of 2024 in Collin County, Texas. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And are those prior convictions true?
Yes, ma'am.
What are the outcome of those last few, 2024 cases?
Judge, I've got the one with 2023 in Hayes County. Is that the one? I believe that. Is that
I don't even have a 2023 Hayes County in here. I've got
I've got
two in Bell County, one in McLennan, and one in Collin.
Colin. We got 200 days in county jail,
Okay.
and let me pull Bell County. Bell County was 9 months.
This is one of those moments that legal observers pay close attention to. What may sound like simple courtroom procedure can actually determine everything that happens next. A single admission, agreement, or statement on the record can dramatically change the direction of a case. If you were sitting in that courtroom, would you take a plea deal or risk taking your chances at trial? Let us know in the comments.
In 2024, it's 9 months state jail. And the Collin County one, like you said. I know. The Collin County was a 1244 to be specific, Judge.
Okay. Let me look at something. I don't think I like it. God, these are so hard to read. I'm printing the PC. I can't see it. Okay, PC. So there's a case from 2017 here out of this court for a 2-year term in prison. What was that for?
No, I had 2 years probation, and then when I went to jail, I had got some jail time with a 1224 age. I don't know how much it was.
So what I'm looking at here, which is even more than what's included on that indictment, shows a 2017 conviction for theft here in Jefferson County, a 2023 in Collin County, a 2023 later that year in San Marcos.
Hayes County.
I was
Hayes
in jail
County.
that whole time.
I don't care if you're in jail. I care that you're continuing to steal, and that I'm not sure that this deal that you've made is sufficient for what I think, for what you've been doing. So we're not talking about a long time ago. We're talking about the last 2 years. So going from literally from county to county to county. So we've got Collin County, Hayes County. Then we're into 2024 where there's 3 convictions, one in McLennan County, one in Belton County, one in Kaufman County. And we're back here with an offense date. So the offense date here was 9/9, which is actually of 24.
Yes, ma'am.
Okay. So at least that one was before the Kaufman County. So you went from here and then you traveled to Kaufman County, within 3 days got another case there. Or at least you had it before and that was the conviction date. Yeah, nope. I will keep the paperwork. Y'all can go visit. I don't think 12 months is appropriate. Somewhere there's got to be a little more than that, in my opinion. Otherwise, obviously, jail time has not been sufficient to deter Ms. Richmond from going county to county and stealing places. So y'all take another look at it. I won't delete it. So if y'all come up with something, I can make that adjustment. If not, if you need some time, I'll reset it and then y'all can talk.
Yes, ma'am.
All right, you're Andre Williams III. And this,
Well, it's the
the second, I'm sorry, the second. This is cause number 24 DC